welcome everybody to our industry update for this month. We are super excited to have our return guest, Pete Muccio, on. Pete is an attorney who specializes in landlord tenant law. So any of you who own rental properties or are working with clients who have rentals, or if you're under contract on a property that is a rental, I really think that this applies to a lot of us. Pete's going to give us an update on what's going on with that market, and we're really looking forward to hearing what he has to say. I know that things have been changing rapidly, so it'll be great to get a current update on what's happening. So thank you so much for joining, and with that, Pete, we'll just let you go ahead and take things away.
All right. Well, Jill, thank you very much. Always appreciate the opportunity to speak with you guys, to speak with the brokers who are on board here, and it's a fun group. And fair disclosure, we've known each other for a long time. Damian and I have known each other for a very long time. Hence the gray hairs, right?
Yeah, it didn't seem like that long ago, but it seems to fly.
Yeah, it does. It does. I mean, it was, just after the turn of the century, and now we're in the roaring 20s. So what can you say?
Yeah.
Well, it's interesting, talking about landlord tenant issues, property management world. This world has just been rocked with changes. We were talking a little bit earlier about how, for the longest time, there's a lot of stability in this area of dealing with property management, dealing with landlord tenant issues, not a lot of major changes. Well, that has caught up, all right? With so many other things that have changed over the past year, there's just been a lot of different changes, a lot of different things happening. It's kind of been, I like to refer to it as a little bit of an alphabet soup type of a situation for landlords to deal with the compliance on, right? I mean, everybody who's a broker knows that, hey, here's the rules that we have to follow, right? We got the book, it's right there. Yep, exactly. So it's
I got the old one. How did you get the new one already?
No, I like to just, I kind of like the color. It's good. The blue theme.
Better than this one. That's
yeah, the yellow. I just skipped the yellow.
Did you?
So, we have all these rules that we have to follow anyway. So there's further complications, right? It's like, for example, here's a printout of one of the different proposed, not proposed, this is the CFPB regulation that came out that impacts landlords in dealing with evictions. How many people before this year even heard of the CFPB when it came to dealing with landlord tenant matters? Probably not too many, right? I mean, it was just not on anybody's radar. And, you got the CFPB, you got the CDC, you got the CARES Act, you've got DOLA, Department of Local Affairs, you've got ERAP, you've got POP, you've got SB 173, you got HB 1121. I mean, there's a lot of stuff, right? And it's a lot for me to keep track of. And I'm dealing with this stuff every day. So if you're not dealing with property management issues 100% of the time, if it just pops up on occasion, or you're dealing, even if you are dealing with it 100% of the time, it's just a lot to keep track of. I mean, just a lot of different changes. And so I think kind of the goal here today, I know we had talked about doing this, a month or two ago, and we're like, oh, you know what, we'll do this in June. It'll be great. Things will have been settled.
Yeah, we really thought that. We really thought that too. I mean, we thought that by June, geez, everything will be figured out and we'll be good.
Yeah. So, I mean, everything is going to kind of come with a caveat that, hey, here's where things are right now, and here's where things could be going, right? And that there's kind of a lot of different changes that could take place. And, we'll kind of talk through some of what those changes are, and, what the current environment is for dealing with a default situation, because I know that's a big concern for a lot of different people. If they have a tenant that is in default, what are their remedies? What can they do? And a lot of these, the alphabet soup that I kind of rattled off, all of those things affect that default situation, that default posture, and how a landlord goes about reaching a remedy, and how they can, deal with that. And, I think the other thing to keep in mind too is that with all these changes that have been proposed, where they've taken place either temporarily or even proposed more permanent changes, there is going to be an evolution in the property management world, right? We're seeing situations where COVID has put a real bright lens on dealing with property management issues and default issues, in particular dealing with eviction issues and what the consequences of those might be. And so we're going to see changes as far as what the requirements might be in lease agreements, and then what the requirements might be in the eviction process too. So it's a whole bunch of stuff, right? And we're not going to cover everything like in 100% detail where you're going to have a quiz and it's pass or fail type of thing. But
if we do that, Pete, we're going to have to give them CE credit. So
yeah, I'm sure. Well, everybody loves CE credit, right? I mean, that's kind of fun. But now we're just going to kind of hit some of those highlights. So where to begin? I think I'll start with kind of one of the more recent things that just took place, and that was working backwards. The governor actually just issued another executive order for this year. And so the governor has been, over the past year plus, has been issuing executive orders that have an impact on various industries and how things are treated. And the most recent executive order is one talking about dealing with the notices and the cure periods that are required. And I'm just going to bring this up here. Let's see if we can share this. So there we go. We should have a copy of Executive Order 2021-110. Is that on the screen there? Yep. Okay.
Yep.
Great.
You got it.
Great. So this one, we got the background and purpose aspect of things, but really going to kind of scroll down here to the amendments, because this is kind of the heart of the bill. And what this does is it changes the time period. It refers to some earlier executive orders that change the cure period on rent demands from 10 days to 30 days. Okay, so this is a requirement. So if you've got somebody that's in default 2 years ago, or a year ago, you would have been giving somebody a 10-day demand. Now it's a 30-day demand. So it was unclear whether or not the governor was going to extend this additional protection to tenants, and he certainly did it. But not only that, this also has some additional requirements here that prior to initiating an eviction action, there is a frequently asked questions that has to be provided to a tenant as well. And there's a link there you can see. There's a Google Drive link that will pop up to those frequently asked questions. Now, interestingly enough, when this order first came out, the link went to an old version of the frequently asked questions that has recently been updated. And let me show you what that looks like. So the key part there too with the frequently asked questions is it has to be given now before you can move forward with any eviction. So that's including an eviction where you had where it's non-monetary. Actually, you'd still have to use that. And hang on a second here. Okay. So this return of service is something that we added on to this because you have to have proof that you serve this, right? That wouldn't be something that you would give to the tenant, but it would be something that you would keep as an internal record to say, hey, look, I gave this to the tenant. But then you've got these additional pages of frequently asked questions where there's information that is providing resources for tenants that are dealing with the default situation. So for everybody that was having to give a 30-day demand previously, now they have to give the frequently asked questions before they can then move forward with an eviction. So if they have an expired notice, they can move forward with that. And I know the question that pops up is, well, why is the governor doing this now? Aren't we getting better? Aren't we, we're giving $1 million away to everybody that's been vaccinated? What's the motivation for this? Well, I think a lot of it actually has to do with another one of those alphabet things that we rattled off, and it's called ERAP. ERAP is the Emergency Rental Assistance Program that is being operated by DOLA. DOLA is the Department of Local Affairs. And this is a program that distributes money to tenants that qualify, and it can pay rent of past due rent, and it can even pay future rent, up to 2 months of future rent, which is a huge benefit. Part of some of the stimulus packages that were done at the federal level got a ton of money going to the states to help get this money out. Now, the problem right now that the state is facing is the state has not been able to get this money out fast enough. Now, there's a couple of things that are kind of creating some road bumps with this. And some of you may have heard of the POP program, the POP. That was a program that had some different funding that was also being done by DOLA. And that program was primarily being driven by the landlords doing the applying to the state directly. ERAP is a little bit different. The state's involved, but you also have different local municipalities where people are applying based on their county and based on their city in some cases that are dealing with the administration. And then there's also additional requirements that the tenant has to provide information in order to get the funds. Where with the POP program, it was largely landlord driven. The tenant did have to engage, but it was a limited engagement to be able to sign off on certain things. So that's created this sort of backlog. So there's a real backlog at the state right now of dealing with getting that money out. So our understanding is that Polis has decided to provide this 30 days to help buffer, to help get that money out to landlords, which it's great to get the money out to landlords. I think that's certainly, these programs have been a huge benefit to both landlords and tenants. And to me, I think that it's better to have a program where assistance is flowing to cure a delinquency or to get some benefit going to landlords. It's better than just a moratorium, because the moratorium would just kind of kick the can down the road because it doesn't solve anything, right? It just delays the pain. But these programs where, hey, we're actually going to take care of some debt for you, right? And we're actually going to pay the landlord so they can pay their mortgage. That provides a huge benefit. But the challenge is overcoming that administrative burden and that timing issue, right? And it's another situation where there's an additional burden being placed on landlords. Most landlords are taking the position that, hey, look, if there is a situation where you've applied and you've been approved, they're going to hold off on moving forward with the eviction for the most part because they don't want to evict you. They want the money, right? As far as that's the main concern. Sorry, I get talking too much and then just
You've only been going for 15 straight minutes. I don't see what the problem is.
I tell you.
And there's a lot to go.
There is. Yeah, we're only getting started. Let's see. Okay, so you get this additional delay, but what else is going on there, right? Are there some additional requirements? I just held up that big packet about the CFPB. Well, so the CFPB, Damian, do you know what the CFPB is? Have you heard of that before?
You mean the Consumer Financial Protection Bureau? Never heard of them. But
all right.
Yeah, RESPA, never landlord tenant stuff. We see a lot of RESPA stuff out of them.
Right, exactly. Yeah, because they deal with like the regulations related to, dealing with consumers, debt collection, lending issues. They can come up with regulations. And it's a little bit of a stretch, but they have taken the position that the action of debt collecting can apply. And if you're trying to collect a debt, then you have to be sort of transparent, right? You have to, you can't misrepresent a situation.
So that's how CFPB wiggled their way into landlord tenant, was the debt collection.
That is the connection. So I don't think it was very common in Colorado, but in some states, there were landlords that were handing over current tenants who they couldn't evict because of the CDC moratorium over to debt collectors. And so that they were using debt collection practices. Now, that's not a typical practice in pre-COVID times, right? Typically, a landlord would go through an eviction process. Once the tenant was evicted, then they might hand the debt over to a debt collector. So there was some question about some of the activities of these debt collectors and what representations they were making about the CDC protections. So the CFPB has taken the position that if you're going to be giving somebody an eviction notice, that you have to notify them of their rights under the CDC or their potential rights under the CDC. Now, the tricky part here is that the CFPB is also saying, hey, look, we realize that most landlords are not acting as debt collectors. So it's a little bit of a head scratcher when, they're saying, hey, look, and before you move forward with dealing with an eviction action, you've got to give this notification to somebody, but they're requiring somebody who's not a debt collector to give this notification. Okay, well, let's just kind of put that aside for a second. Requirement is actually fairly straightforward in that they did provide kind of a safe harbor saying, hey, look, you can comply with our requirement to notify somebody about their rights or potential rights under the CDC protections by putting a little blurb about a phone number so that they could call a counselor and a website that they could go to. So what we've done is we've put onto our existing rent demands a blurb, and let me bring this up here.
Oh yeah, that's at the top.
Yep, that's at the very top. So that's new at the very top, and that's directly from the CFPB guidance to say, hey, look, this needs to be on there. And if you don't have this on here and you serve a demand, you could open yourself up as a landlord, or you could be opening up your attorney to a potential violation of a Fair Debt Collection Practices Act, which could then lead to recovery of penalties and attorney's fees. So it's one of those things where the compliance, like there's really some questions as to the viability of this requirement, but the risk reward of you can add a disclosure, or you could risk a potential lawsuit and penalty. It's really, it's kind of an easy balance, I think, to sort of figure out. So that connects back to the CDC.
How many people don't know about that though, Pete? I got to tell you, that's the first I've heard of it. That's insane.
Yeah, no, it's pretty wild. It really is. And it's fairly new. And I think it's only been around for a couple of months. But yeah, when it first came out, we were really trying to push that information out to let people know that, hey, look, and getting this up on the website. One of the things that's challenging is people for years, again, going back to, hey, notices haven't changed, and there's been a lot of things have been the same. We've seen notices from decades ago that people had used, and then so it's a matter of updating people and saying, hey, look, you've got to use this now, right? Use this current rent demand now to deal with that. So, which relates back to the CDC. So the CDC, Centers for Disease Control, I don't know, had that really, it come into play last year big time, right? As far as dealing with the spread of Corona and everything like that. But it didn't really factor into housing so much until there was a request from the president to say, hey, look, give me something to deal with slowing down evictions. And so the CDC came up with a order that basically, it's not a blanket moratorium, but it's sort of a shield, if you will, that gives tenants the opportunity to stop an eviction if they make a declaration that they're being impacted by COVID. They only make a certain amount of money, and that if they were going to be evicted, they could be in a very limited housing situation or homeless. And so that only applies to situations dealing with non-payment of rent. So if somebody were facing eviction for non-payment of rent, they filed that declaration, the landlord would have to stop the eviction action, in the sense that they couldn't continue on with moving forward with evicting them. They're actually entitled to move forward with getting a judgment for possession, but it's supposed to be stayed. Now that's a kind of an important distinction that not all courts in Colorado agree upon, right? So, judges are human, right? So they've got different perspectives and different interpretations of the law. And there has been some variation as far as when and how far you can go with the eviction process before you have to stop, and stopping short of the physical move out. But if you went forward with the physical move out, then you could be subjected to criminal sanctions. And I have yet to hear of a situation where that has taken place, but it's certainly possible. And also, again, civil penalties. So it's a huge protection, right? When you're talking about non-payment of rent, a lot of people having issues with rent, and so that could stop the eviction. That ties back to the CFPB. If landlords or attorneys or debt collectors were not being candid about what somebody's rights are, that they could stop the eviction by giving a declaration, that's not right. And so that's the connection that the CFPB was trying to draw with the CDC. Now, the CDC has been challenged multiple times in multiple jurisdictions about the validity of their ability to issue this type of order, right? So the CDC's order is couched in the, hey, look, we need to protect people from the spread of COVID-19. And as time goes by and more people are getting vaccinated, it's becoming harder and harder to justify that situation. We've got multiple courts that have said, look, this is unconstitutional. It's an overreach of the CDC's powers. But right now, those cases are on appeal, and the CDC moratorium is set to expire at the end of June. I have some thoughts about whether or not that's going to get continued or not.
Hey, why don't you get your crystal ball out, Pete? Tell everybody what you think.
Yeah, all right, let's kind of rub the crystal ball, look at it.
It's not a magic 8 ball, Pete. You don't have to rub a crystal ball. Go ahead, I'm sorry.
So basically, I think it's going to get extended to the fall sometime. I don't think, I think we're going to, certainly the vaccination rates hopefully will keep increasing, but I'm expecting a continuation until the fall. Damian, any thoughts over under on that?
I'm with you. I've been thinking for a long time that it's going to be September. I think a lot of it's going to be driven on vaccination rates and that kind of stuff, because at some point, you and I talked a little about, I don't know what's driving this other than I think there's a lot of politics involved. I'm not sure coronavirus is driving the eviction moratoriums anymore so much as it is economics and politics and concern about, what's going to happen if everybody does evictions all at once and those kind of things. But at some point when you have an eviction moratorium lift, there is going to be damage. But there's only so long you can justify it. If vaccination rates get up in the 70s and 80s, what's your justification at some point? But yeah, I don't have any idea. You know better than me, but that's kind of what I was guessing too.
Yeah, no, I think it's, I mean, the politics that have come into play are really surprising, on both sides. And, you look at the CDC issue. I mean, this crosses over from two administrations, Republican and Democrat. So, you can't just really say it's really all on one party. But I think, both parties will, kind of put their spin on things, regardless of what's going on. And it's tricky. I think the other thing that's tricky and that we're seeing really at the state level too, which is a nice setup for the segue to the next topic, is that people really don't want to look at being responsible or having a connection to dealing with an eviction, right? And I think that there's a big misunderstanding or a big misrepresentation that's going on, is that the landlords don't want to do evictions, right? That is not where landlords make their money. They're not setting out to evict people. Landlords want people to be in their homes and abide by the terms of their lease agreement. And, sometimes that doesn't happen. And there has to be a consequence to that and a remedy for that situation. And the most common breach of a lease agreement has typically been the non-payment of rent. And we've seen a lot of that's gone on for the past year. But what we have also seen is we've seen tremendous actions on the part of the state, on the part of the federal government to provide protections in place. But we've also seen tremendous actions on behalf of landlords, recognizing the situation, offering up proposals and plans, working with people, coming up with creative arrangements to try and find solutions, and really, have a good dialogue. I've seen the flip side of that, where people have, tried to take advantage of landlords, and where there's resources available, and some tenants have known that, hey, look, it's difficult right now to go into court, and or there might be a moratorium that's in place, because last year we dealt with multiple moratoriums, and they knew that there were limited remedies that the landlord would have. So it's a tough issue, and I think the state, at the state level, we're seeing proposals that are trying to, some of them are couched in, hey, look, we've got to address certain things because of the COVID-19, but a lot of them are really pushing forward different agendas that we've seen from tenant advocates for a while, that is really going to change the landscape of dealing with a default situation. And you've got changes at a couple of levels. You've got changes that are being proposed at the level of the lease formation. And one of the bills that's out there is Senate Bill 173. And I've got a copy of that up, but I don't want to really dive into the minutia of it. So if you want to really look at it, you can do a search on the legislative homepage, and it'll pop up Senate Bill 173 of the 2021 session. And the bill has been dialed back from what it initially was, which was this huge overhaul and this huge thing where it was going to create severe penalties for landlords that failed to have a limit on their late fees, and to the point where they could be facing criminal prosecution from attorney generals on dealing with that from the attorney general office, right? Or private causes of action where they could be sought for treble damages and attorney's fees for violations of the Colorado Consumer Protection Act, which it can be very expensive to litigate, tens of thousands of dollars easily, if not six figures, in attorney's fees for either side in litigating those cases in front of a district court. So initially, and there was talk about eliminating waivers for jury trials. There was all sorts of kind of a hodgepodge of things that were included in that bill. There's still quite a few things that are included in that bill. It's been amended down. There's no longer the connection to the Consumer Protection Act, which I think is beneficial. There's still limits on late fees, both as a percentage of the rent and as a minimum late fee potentially. And that could all change too. We still don't know. It's still possible that there could be amendments to this. It has not been finalized, but I think there's a chance that it may pass and may go to Governor Polis for signature. On the other side of the eviction process, there's delays, right? So things are going to take longer, is I think the short version of that, whether it's from once you have a judgment to when you could get the writ of restitution. Right now, the writ of restitution can issue after 48 hours from the judgment. With some of these proposed changes, it would issue after 48 hours, but it would be at least 10 days before the sheriff would be able to move forward with the physical eviction. And there's other proposals that will slow down the process as far as once you get into court and kind of stretch things out. And potentially, if things go slower, what that ultimately means is it's more expensive, right? Because if it takes longer to do an eviction, that's longer to resolve a situation involving a non-payment of rent, or dealing with a problem resident that's creating disturbance at a community. And it also is probably going to cost more as far as dealing with the time, dealing with attorneys. And so all of those things have a huge, more of a macro cost on housing as a whole. And I think it's overall, the proposals are more negative to all landlords, but I think it's going to be a real hit to somebody that has one or two properties, right? I mean, are they going to be in a situation where they're going to say, hey, look, I want to deal with the compliance and the risk associated with this? So if they decide, hey, I want out, what's the biggest way that they get out?
Yeah, they're going to sell it.
Yeah, they're going to sell it. They're going to say, hey,
sell it. And we're going to have less affordable housing or less units available for people that need rentals. And
right. And so when that's gone, it's, those houses are gone, and we already have a housing shortage, right? So I think that's
Brokers don't know that. They aren't. These guys aren't aware that there's a housing shortage. That's news to them.
right.
It's funny, Pete. You were talking about amendments to that bill. There's people on here that are actually with Cars LPC and NARPM, and I know that your group also did a lot of work on working with the legislature to try and roll back some of the more catastrophic provisions, and that's, it's, we'll actually have Liz Peets on in July to talk about some of the stuff that CAR did on some of these bills. But yeah, it's better than it was. It's still not perfect, but at least it's better.
Yeah, it is better, and it's nice to see the improvement. And I think one thing that I think would be beneficial for those involved in the management side is to have improved coordination between the different organizations that are advocating on behalf of landlords, whether that's the Apartment Association, Metro Denver, the Colorado Landlord Legislative Coalition, and CAR. I think more coordination between those three groups, I think, could only strengthen the voices of everyone down there at the legislature. So I did have the opportunity to speak on a couple of the bills. Well, actually on 173 in particular, both virtually and then in person. And there's something about being down there in person, even with everything going on. It's just, fair disclosure, political science was, my hard sciences as far as my undergrad, right? And so it's just fun. I was just kind of geeking out about being down there, but it's tough. I mean,
did your mask fit over your beard?
I think they've got to have some beard accessible masks that really, kind of have like, yeah, so it's interesting. I mean, interesting changes, certainly, coming forward.
And before you move on to the next section, I think there's some questions, and some of these we may have left in the dust a little bit. So I'll let Jill go through a couple of them, and then you can go on with the rest of the presentation.
Perfect. All right. This person said they missed what the new disclosure needs to be on the rent demand notice. Where can we find the details? Is that available on your website?
It is. And so I would say, gosh, let me see. I think I can put it on the chat here. I'll just put our website in on the chat. And if you go take a look at that, offer.com. So if you go to our website, and if you take a look at eviction forms under the 30-day form, that disclosure is on the form. And it's common that we get questions about, hey, can I change the form? Can I, put it on letterhead and everything like that? Because of the requirements with the CFPB, we're recommending people just use our form as it is. It doesn't mean you have to use us for an eviction. We don't have a login for that form, but the challenge is that if you were to modify the form, you could inadvertently do something that might run afoul of the Fair Debt Collection Practices Act. So if you did something like changing the font size and shrinking it down from a larger font to like an 8-point font, that could be problematic for you, because you could say, hey, look, I've got the disclosure on there, but if it's too small and if it's kind of hidden, that's not going to fly. So.
Nice.
Okay, is the POP program still active for landlords or any other programs? I know you touched on that. Do you mind just giving a brief overview again?
Yeah, so POP, I think, is winding down. I don't know if they're still, I don't think they're taking new income.
I think it's anything that's past due from February was what, so, my mom has a bunch of rentals, and she got rent for POP through February, but then after that had to change to ERAP for a couple of her tenants.
Yeah, so that makes sense. I don't know if they're still processing anything that was sort of left over in that program, because they had to really change gears. And that's, we all know how difficult it is to change gears, right? Never mind if you're dealing with, thousands and thousands of people applying to you and throwing stuff in. So they've got a tough challenge there. But yeah, I think
or if you're the state and federal government.
Yeah, exactly. Not exactly known for their nimbleness, right? Yeah, so I think in addition, those aren't the only programs that are out there. There's a lot of different groups that have put together resources, raised money to try and provide support. I would say if you take a look at the Apartment Association of Metro Denver, their website, they've got a link to other, a resource page too of other resources that tenants and landlords can connect with. So outside of just the state programs too. So there's a lot of different mechanisms for assistance that are available.
Okay, we own an RV park, and as soon as the governor said that they didn't need to pay, a tenant came in and said he is no longer paying because he didn't need to. Then in court, he lied to the judge saying he had applied for assistance. Now he's living rent-free and we can't do anything. How do we get him out? He owns his unit and rents the space.
That's a larger conversation, but
It is. You know, I would say that you might want to reach out to an attorney. If you want to reach out to our office, you can take a look at our website, and there's a way to do that. It is challenging dealing with somebody that's not being truthful, and you know, that happens on all sides of different litigation at different times. And so it could be a matter of finding the proof to support your argument. Also, you know, things might be changing as far as depending on what sort of protection they were really falling under. And then is there anything else that they might be in violation of too? And the other thing this has been going on for a long time. So a lot of situations where people were under a lease, those leases have expired. There might be situations where people can non-renew leases and go moving forward based on a non-renewal, not based on the non-payment of rent. So.
How does the moratorium work if you have a renter that is severely behind on rent and utilities, has been non-responsive for months, and his lease is up at the end of August? Can we use the lease termination as a justified eviction?
Well, so if somebody has, so the current moratorium that's in place right now is really dealing with the CDC. So if somebody's giving you a CDC declaration, they are swearing basically that all these protections are in place, and that they, part of that too is they're saying, hey, look, I have exhausted or I've tried to get assistance. Now, if they're not communicating with you and they're not trying to get assistance, then depending on the jurisdiction that the property is located in, you might be able to challenge that that declaration and have a veracity hearing, right, to test the veracity of that declaration. So again, that's something that's probably a more in-depth conversation to have with an attorney. But it's possible to challenge that. And some jurisdictions are more open to that type of a challenge than others. I mean, some will require what I like to call the Cadillac level of proof. You might say, well, what do you mean Cadillac level of proof? I mean, you want to have evidence that the tenant's going out and buying a Cadillac instead of paying the rent. And that example is a real life example.
I thought you were going to say jet ski, but
yeah, jet ski works too. Cadillac, it just has nice, it rolls off the tongue. I don't know.
There was a part B to that last question. And this tenant also receives a stipend from Denver Housing Authority, but has basically not paid their portion of rent in close to a year. Should we get the DHA involved?
Absolutely. Absolutely. I think you need to contact them and you know, have that dialogue and, you know, see what's going on there. You know, I mean, you hate to hear about situations like that because all the housing programs that are there for a reason. There's a need, right? And when you've got somebody that's abusing that program, they're not taking advantage of what it's really there for. And they're also taking a spot in that program from somebody who also might have a need that could really benefit from that program. So have that dialogue with DHA, see what they can do. If you don't make progress there, then feel free to reach out to our office about you know, how we might be able to assist you with that.
There's a question here about, are there any current laws or regulations that prevent landlords from raising rents? They're either long overdue, should have been increased, or they're under market value. Anything preventing that?
Well, that is a nice segue into another bill that we didn't talk about yet, but I'll touch on it right now. So that's a good setup. So basically, there is a proposed bill that would limit the ability of a landlord to increase rent only one time each year, every 12 months. And that's a huge change. You know, it's basically rent control.
Can you talk about the status of that bill, Pete, and where it is? And because I don't think it's finished yet, but maybe if you can read tea leaves again, I'm going to make you do tea leaves since you wanted to rub the crystal ball before. What you think?
Yeah, no, exactly. Well, it's either that or the Kreskin thing. I think that's Johnny Carson.
Okay, Johnny.
Yeah, that's right. That's some wild, wacky stuff. Yeah. So I think there's a good chance that might pass. So that was House Bill 1124, I believe. In fact, or 1121. Actually, I think I've got a copy of it.
1121. Yeah.
1121. Okay. Yeah. So it is. It's been dialed back a little bit. So there's some, again, talking about the delays in the eviction process. I think there's a good chance that might pass. So it is, these things are, so we don't have a whole lot of time left in the session. And I think it's still possible that it could get amended, but I'm just not sure there's going to be that big of a push to get it amended beyond what it is right now. I think it's going to pass. I would be surprised if the governor didn't sign it.
Do you know if it has a safety clause, or is it going to be effective immediate? I mean,
that was effective immediately.
It would be effective immediately.
Would be effective immediately.
Safety clause.
Yeah. So the other bill, the 173, is a little bit of a compromise. Right now, it would be effective in October. So it's good that there's some delay there because there's penalties in there as far as what your late fees would be in a lease agreement. So if that bill were to pass, everybody's going to have to amend their leases. I haven't seen a lease in existence that would just automatically qualify with the requirements that are in that bill that I could think of off the top of my head. I'm sure there might be one out there, but it's just there are changes in there as far as dealing with, well, one, the amount of late fees, and I'm sure the rates are much lower than what maybe a typical lease would have, but then also you can't classify late fees as rent. And so I think that's a fairly common thing that happens right now in a lot of leases.
Okay, this is a long question, but an interesting scenario. So I received my money for 7 months past due rent and 2 months in the future, making me whole through June. However, I'm in the process of evicting due to breaking other terms of the lease, like not paying for utilities, removing smoke detectors, CO detectors, 2 grow tents, and over 40 plants in my basement in a condo. We gave them a demand on May 8th and gave 10 days to take care of those issues, which they didn't. So the law firm filed demand for court on June 1st. Tenants never appeared or filed a response. So they filed a motion for entry of judgment for possession yesterday. I was told once judgment enters, we have to wait 48 hours for writ to issue. Does this sound like we are moving forward with eviction? Well, we will have thousands of dollars in repairs to get it rentable once again.
Well,
that's an eviction.
Yeah, it is. And, once you have a judgment, then you're looking at moving forward with the timelines that used to be in place are thrown out the window a little bit, right? So, for example, when you're asking for a judgment, it used to be on the day of court. If somebody didn't appear, you're asking for the judgment that day, and typically it would get entered that day. That is not the norm now. So in some cases, the courts, because a lot of things are virtual, we're kind of joking around earlier about, well, hey, there's no good excuse to be late if it's virtual, right? Well, go to court and you'll hear all sorts of excuses of, hey, here's why I'm late and whatever. So the courts give more time now for somebody to file an answer. Typically, they might even give till the end of the day in some jurisdictions, and where they might have used to give 15 minutes or maybe a couple of hours. And so everything takes a little bit longer. But yeah, the short answer is, yeah, you're on the path to getting the judgment. And once you get the writ, then it's scheduled with the sheriff and moving forward and dealing with that. So.
Someone's asking if they can get a copy of your 30-day demand notice. Is that available on your website?
It is. So if you click on that link of the website, you go to our eviction forms, and it's on there as far as the 30-day form. So that's the easiest way to get that.
Perfect.
There's no login.
person asks, I took renters to court to move or pay up the back due rent. They moved, owing me 3 months rent and damages. What can I do? What is the best way to go about it? This was back in January. So in court at the time, I couldn't bring up the fact that they owed me any money. It was just to get them out, said the judge. She said I could come back after that and collect the back rent.
So, that type of situation, it probably makes sense to look at pursuing them with a collection agency to help move forward with trying to collect in that vein. You can try to do collections on your own, but if you don't have the time to get up to speed with how to do a garnishment, how to do skip tracing, you might look at hiring a collection agency that will take a percentage of what they collect, but they have those resources built in. You're paying for, their expertise in having somebody to investigate and find out where that person is, for pursuing that judgment or for getting a judgment if necessary, if they can't collect it without that. So I think that would make a lot of sense.
Okay. These are great questions. Thanks everybody for putting those in the Q&A. Okay, so this person says, eviction is ugly. What about a lease break? If a renter is buying a home and wants to break their lease, let's say they're buying a home, but can present another tenant who is a reasonable substitute for themselves, is the landlord required to accept that substitution, not as a sublet, but as a replacement? Seems to be a way to ensure a tenant doesn't have to coordinate their purchase with the end of the lease.
Well, Dan, certainly there is an obligation of a landlord to mitigate their damages if they're dealing with a situation where a tenant's moving out, right? So if somebody's saying, hey, look, I'm out of here, and they come up with a substitute tenant, a landlord can't just say, oh, you know what? Look, I got you on the lease. I'm just going to sit back and relax, and you need to pay me the rent. No, you can't do that. You've got to try to get the property re-rented. So if they are coming up with a reasonable substitute tenant that's looking good, that's something that you should really consider, because otherwise, you could have some challenges in dealing with your mitigation. If you're going to deny that person to move in, you better have a good reason for denying them.
Hey, Pete, along those lines, one that you and I discussed several months ago, what if they have a lease break provision in their lease that says that, hey, if you decide to break the lease early, you have to pay a termination fee or something along those? Do you see those getting challenged by some of these statutes? And what about mitigation of damages and those things? Am I making clear what a...
Yeah, absolutely. You are, that's one thing we didn't talk about in 173, talking about the limitations in lease break. So, one of the things that was put forth in there was talking about eliminating the ability to have a lease break provision, which, that could be tough, right? Because the benefit of a lease break is that you can have a known amount, like, hey, look, if your lease breaks, it's going to be 1 month of rent or 2 months of rent. But I think the problem is that, there was a little bit of maybe some overreach with some of those lease break fees where they were getting really high and big numbers. And so there's pushback on that.
Yeah, well, then there was demand, right? There was demand for the place. They knew it wasn't going to take them long to lease it, but they're saying, oh, if you want to break it, then it's 2 months or it's 3 months or something like that, which, yeah.
So what happens if you're not having a lease break fee is it's going to go back, things will revert to a future rent scenario. And the future rent is, hey, if you've got a lease that runs for 12 months and you break on month 8, you're still responsible for month 9, 10, 11, 12. There's still a duty to mitigate damages to try to get the tenant, a substitute tenant in there, but you don't have this sort of like, hey, here's your fixed amount. It's, whatever the amount is under the lease. But part of that also has to tie back into your existing lease agreement, because if you don't have magic language in your lease that allows for you to collect that future rent, guess what? The landlord could be left out in the cold, right? So.
We have a tenant who is planning on moving out at the end of the month. What can we do if they decide to use their deposit as their last month's rent?
Well, that happens quite a bit. Unfortunately, there's probably not a lot that you can do other than you'd still have a claim for dealing with the damages beyond normal wear and tear to the property. And it's just, You know, they're not allowed to use the security deposit typically when they're still living in the property. Now, some landlords did come up with arrangements with tenants to say, hey, look, you know what? You need that to cover a month of rent. It's a tough time. Fine, that works. But the involuntary using of the deposit by a tenant happens quite a bit. And unfortunately, when that does happen, then you're left with trying to pursue a collection if there are damages beyond normal wear and tear. But you still have to account for the deposit after somebody moves out too. If somebody says, hey, look, I'm using that for my last month of rent, I'm out of here. Don't skip out on doing the security deposit disposition. You're going to want to still do a disposition that applies the deposit to that rent. Because the last thing you want to do is you don't want to give them a cause of action for them to come back and say, hey, you didn't account for my security deposit, so I'm going to sue you for 3 times the amount of the rent if you don't give me my deposit back.
Okay, a few more questions here in Q&A, and then there's some in chat. If we're okay to keep firing away questions, or did you have more you wanted to present? Or
I think we covered a lot of stuff. So I think if we're answering the questions, we're probably on the right path.
okay, perfect. All right, so can someone use the eviction moratorium even if the landlord is just not renewing the lease? Example is the landlord gave 30-day notice for tenant to leave after their lease had expired and was month to month. Tenant used the moratorium to say they couldn't leave because they couldn't find housing and would be homeless if put out.
That's not really what the moratorium is designed for. And a proper application of looking at, hey, look, is this appropriate or not, would say, hey, look, you can't do this. Now, I have seen situations where I think courts have gotten that wrong, and they have misapplied that or misinterpreted that. And I've seen them where they get it right. And more often than not, I've seen them get it right dealing with that situation, but there's always a few exceptions. So.
What has replaced the 3-day notice to quit, a 10-day or a 30-day notice?
So right now, unless your lease requires otherwise, you can give somebody a 21-day notice to quit prior to the end of the month. So if your lease is silent, you've got somebody on a month-to-month basis, you can give them a notice to quit for 21 days prior to the end of the month.
And then it's 30 days if it's COVID, or is it just 21?
So, well, this goes back to the CARES Act. If you had a covered property, so
Right.
you can have a situation where if you had a covered property and you're giving somebody a notice to quit, then you'd probably want to be giving them a 30-day notice to quit. Now, there are a couple of jurisdictions that have taken that portion of the CARES Act really far and said that, hey, look, any eviction notice, that's related to rent even has to be a 30-day notice to quit. So that's one of those things that's out there that's subject to challenge. But if it's a covered property, and I know what you're saying, Pete, I don't remember you talking about a covered property. What's a covered property? Right?
Why don't you tell them what a covered property is? It has a roof on it.
It's covered under the CARES Act if it's federally backed mortgage, right? So if the mortgage that's on the property is backed by, it's a Fannie, Freddie, it's a federally backed mortgage, it has a connection to the federal government, which most mortgages do, but not all, then it's considered a covered property. So if you don't have a mortgage on the property that's a rental, you're not covered. And that's just dealing with the CARES Act piece of it and dealing with that 30-day requirement on notice to quit. You could see where, if there's a quiz on this, it could be really tricky. I mean,
yeah, that's why I wanted you to kind of cover, because 21 sounds good, but not always.
Yeah, there's an exception. And
Yeah,
I think that's the tough part too about, especially if you're dealing with properties in multiple jurisdictions county-wise, right? I think it gets tricky because you could have variations as far as how the judges might be looking at things that might not be uniform. And, it's just, it's tough.
Okay, I'm going to move over to chat here because we've got a bunch of questions in here. So we'll kind of rapid fire. All right. So this person
I
has a
think some of
tenant.
these were actually asked in the question and answer too, Lenny, so.
Yes, yep, I think so. So we'll try to not duplicate here. So I have a tenant which was just approved 10 days ago by the rental assistance to cover 2 rent payments, June and July. As of now, I haven't gotten a payment from them. Today, I posted the 30-day notice from Cheddar Sulzer, as well as the return of service DOLA FAQs with a 5-page printout. The lease agreement goes until August 9th of 2021, and the owner wants me to post already a non-renewal notice. If the tenants do not move, can an eviction started base, I'm not sure what we're trying to say here, eviction started base that the lease came to an end.
So I think I got where that's going.
Okay.
So a couple things. One, Ruth, we just pushed out, and I think the email went out that there was a new the DOLA FAQs. So hopefully you put the recent ones out there. The initial ones that we sent out, I think Damian and I were talking about this earlier, that the original FAQs weren't updated. Like somebody over at DOLA had updated, but they had changed the date, but they were actually from February. So DOLA has since re-updated those, and they're a little bit shorter. So you might want to make sure that you get those correct FAQs out. You have received assistance, or they've applied for the assistance. So if you end up accepting the assistance, you can't move forward with the non-payment of rent situation, right? Because you can't have your cake and eat it too situation. But serving the non-renewal for the end of the lease, since it's going till August, probably makes a lot of sense, especially if they're going to get those payments. But that's probably a good way to at least posture that.
Okay, I have a client that wants to sell his 6 leased units. The lease terms do not limit him to sell at any time. Does the CDC or Fed regulations affect our ability to sell to an individual that does not want the tenant to sell?
So I think I'm reading that as that. Is there any restriction on them selling the property? Tenant says, "Hey, look, don't sell the property." They don't have. It's not the tenant's call, right? So you can sell the property if it's tenant occupied, and just the new owner is going to take the property subject to those lease agreements, unless there's language in the lease that would allow you to terminate upon the sale. That language does exist in some residential leases. It is very uncommon though, and that is rare. So there's no restriction on you selling a property that is tenant occupied right now.
Okay, I have made a mutual agreement with my tenants for them to leave my property after non-payment. Am I subject to being sued? I think I have not issued, is that right, Ricky? I have not issued a 3-day pay notice or anything.
So you cut a deal with somebody, they're going to move out. Can they still sue you? Well, this is America. You can sue anybody for anything you want, right? I mean, you really can.
It's
Now,
job security.
yeah. I mean, it's the thing is whether or not you're going to be successful with that lawsuit, whether or not there's going to be a good defense, and maybe there's a defense in the agreement. Maybe there's who knows. So I think that I have a client that likes to say, if you want to make sure that you never get sued, don't own or rent property, right? Because it's inevitable. It's going to
And
happen.
don't walk across the street, and don't have people over to your house, and don't drive cars, and we could go on.
Yeah, exactly. So, I mean, it's possible there could still be a suit, but maybe there's some protections there in whatever the agreement was that you signed. But just because somebody files a suit doesn't mean they're going to be successful with it.
Okay, renter is past due 4 months. Lease comes up for renewal August 31st. Can we issue a notice that we will not be renewing the lease and they will need to move out? We feel the tenant is taking advantage of the COVID eviction moratorium and they're planning to sell. They want to sell the property.
Yeah, that sounds like a plan. I've heard some people make rumblings that they think that the CDC moratorium should apply to a non-renewal situation, and it really shouldn't. It's not designed for that. It's not designed to force a landlord to provide housing beyond the term of the lease agreement. And, again, there's no guarantees when you go into court other than you don't know exactly what's going to happen. But ultimately, the court should not be allowing the tenant to stay in that situation.
I think we're winding down here. When a tenant breaches a lease by moving prior to lease fulfillment, is their security deposit forfeited?
So I don't really like to think about a security deposit being forfeited. Right? Think of it as being, it's to offset. It is to use as a credit to apply against a future default. So if somebody's moving early, then there's probably liability under the lease agreement for future rent. Maybe they owed something, and that's what it should be offset against. But try not to look at a security deposit as being just forfeited and it's gone, because you still have to account for it. It's still other people's money, and it's a huge area of the law that is very tenant friendly. So if you don't do it correctly, you could still be in a situation where the tenant could owe you money, but you could owe the tenant money because he didn't account for the security deposit correctly.
If an owner has not fixed water damage and the tenant now wants to break the lease since the owner hasn't fixed it, it's causing the basement, which is finished square footage and being used, which hasn't been able to be used because the owner has not fixed the damage. Could this be grounds for a tenant to break the lease?
Hello, warranty of habitability, Pete.
Look at this guy. Yeah, exactly. I mean, it's total warranty of habitability issue there, and there's a lot of exposure there for not making a repair. So I think it would make sense to have a serious conversation with the owner about where they want to go with this, and kind of evaluate where you want to go with the owner, because why that property wasn't repaired could certainly create exposure for both the owner and for the property manager. So.
All right, I think we've got two more quick questions. One was a follow-up to the question about, can a tenant find a replacement tenant? Is there a performance standard to hold them to? In other words, how or when they go about finding or presenting that replacement?
I think there's not a hard and fast rule book for getting a subtenant in place, right? That you can say, hey, look, here's sort of my checklists. I know it's great to be able to say, hey, look, what's the system here for dealing with this, right? But I think the way I would look at it is, if the tenant has somebody lined up, screen them and see if everybody can get on the same page as far as, yep, they're a good tenant and they're going to take over when they're going to take over. Right, and see if you can get all that kind of pulled together.
Okay, we'll answer these last two, and then we're going to let Pete get on with his day. Thank you, Pete, for your time. So a tenant has month to month in the RV park. That question just disappeared. I'm happy to answer, or we're happy to answer that one if you want to put that back up.
I answered it, honey.
Oh, you already answered it. Oh, okay, perfect.
Yeah. It was about HOAs, and I don't think that one's really applicable to what we're talking about today. So.
Okay. So last one, tenant has month to month in the RV park. They've not paid rent and they've abandoned the unit. The unit is still in the space, but completely gutted. Do we have to go through eviction, or can we go through abandoned vehicle storage lien? Not sure if this is your wheelhouse, Pete.
Well, I would say abandonment is a very fact-dependent situation. So that's going to be the caveat on this. It's possible that you could go through the abandoned title process to get title to the RV, but there's a lot of different factors to look at. So you want to make sure that the property truly is abandoned. And if there's a lot of confidence that it is abandoned, then you could probably go through that abandoned title process and to get title to the property.
Terrific. All right. Thanks everybody for all the questions. Damian, was there anything you wanted to add today?
No, I'm good. I just let Pete talk.
Yeah. Pete, thank you so much for your time today. I know you are so busy and you are just an absolutely incredible resource in this field. And so thank you for being so generous with your time and joining us over and over on these updates. I know everybody really appreciates all the wonderful information that you provide. So thank you so much for your time today. We really appreciate you. Thank you to all of you for joining us. Thanks for your support of these industry updates. We really appreciate that. You've been here joining us each month, and we hope you're getting a lot of value out of them. And please think of Heritage Title and your sales rep if you have an upcoming listing we can help you with. And with that, we'll sign off and we'll see all of you next month, first Thursday at 2 o'clock.
Thank you.
All right.
Thanks, Pete.
See you later. Thanks again, Pete.
Bye, guys.
Bye.